Hi everyone, welcome to Active Self-Protection Extra. Today on John's Briefs, back again, it's one of my very favorite attorneys, Tim Forshee. And I want to talk, I recently watched a video. One of the channels that I follow is Armed Attorneys, and I like them. I think you should subscribe to them. Good folks doing good work. And they recently had a video about your training being used against you. I actually put a comment in that thread about the Federal Rules of Evidence 404. I'm going to introduce you to those today with the attorney and why I had that question. To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below. So their argument was that they are seeing some clients who their training record is being brought into question, and their expectations of training, and even seeing maybe some firearms trainers being subpoenaed, and what was their curriculum, and then did the person follow that advice and those things. And I asked the question, what about Federal Rules of Evidence 404? So can you explain to us what that rule is?
Yeah. Federal Rules of Evidence 404, essentially, we refer to it as the prior bad acts evidence rule. And basically, I started asking you, are you familiar with, of course you're familiar with the Harold Fish case.
Yes. Well, we actually did a whole series here on Extra about Harold Fish. Please go watch that. It was an insane case.
Very famous case. So the decedent in that case had a criminal history of assault, mental illness, had a sharpened screwdriver in his back pocket, and the issue became
two aggressive dogs,
which Harold Fish fired warning shots to ward off, but then didn't fire a warning shot, which we could talk about warning shots for another half an hour.
And we will.
But the issue with that case was that this guy had prior bad acts, but the jury was not allowed to hear about them. And the reason that the jury was not allowed to hear about them was because Harold Fish was not aware of them at the moment he had to make his decision. If I was a retired cop and I knew that I'd arrested you for domestic violence 5 times, now my knowledge of your proclivity to domestic violence would weigh into my decision-making process, and the jury would be allowed to hear about my decision-making process. But if I didn't know about it beforehand, it's viewed as too prejudicial for the jury to hear it with regard to the defendant's rights or the victim's rights.
Right.
So that's kind of Rule 404. You could talk for. I mean, that's your Rule 404 is probably 2 weeks of law school. I mean, it's kind of hard to nutshell it, but essentially what it means is that there are certain things that the jury can hear about your record, your prior bad acts, and there are certain things they can't.
Now, again, though, as the defendant in a criminal trial, if you want to enter in your character or your prior acts, you can.
Well, if you say something like, well, gosh, I'm a really good guy and I've never been in trouble. Now you just open the door, because now the prosecution is going to go, what? We just pulled your NICS record and it turns out you were arrested for assault 5 times in 1984. You've opened the door. So you've heard that before. That's a common, you even see it on like Law and Order. But yeah, if you open the door, that allows the other party to walk through it. So you have to be very careful not to open certain doors.
Now, of course, that's interesting because if you're going to get a self-defense instruction in a self-defense case, you're going to have to talk about those things.
That's exactly right. And I've been a big advocate for years, and I think you have as well. I've been an instructor, a CCW instructor and legal force instructor for about 30 years now. And I've always advocated get as much training as you can, hopefully good training, and document the heck out of it. Every time I take a class, even if it was a class I didn't really like, I still learned something. I might have learned how not to do it or how not to teach it. But I keep all the documentation. I keep the CV of the instructor. I keep a photograph or the actual target that I shot or the targets that I shot, a copy of any written exams, any documentation at all. And I keep all those in a binder with a tab, okay? March 4th, 1986, this was the class I took. The next tab 2, this is the class I took. And once the notebook gets full, I put it in a Tupperware container. When the Tupperware container gets full, it goes in my attic. I'm on my 4th Tupperware container over these years. If I'm ever accused of a crime, and by the way, I give credit where credit's due. I think the first time I actually sort of codified this concept was when I took my first class with Massad Ayoob. I'm a big advocate of this as well.
And Massad would tell you that you want to put it in an envelope and mail it to yourself and leave it sealed so it can be opened in court.
To show that when you had it. That's right. The poor man's patent concept. Yes. But I'm a big believer in that. I appreciated it before, but I think that when Mass taught it to me, it was like, wow, this really does make sense. So, and if I'm ever accused of a wrongful shooting of some sort, if I find myself in court, Defense Exhibit 1 is going to be 400 pounds of paper, and you're going to see that this is the effort, the time, the money that I spent to be better educated about this, to be more competent, to be safer. What's the difference between a 22-year-old recent graduate from the police academy and the 52-year-old retiring captain of the SWAT team?
Yeah, a ton of
Education
experience.
and experience.
Yeah.
That's all it is. So I'm never going to be, despite what the armed lawyer said, I'm not going to be afraid of getting that training, okay? But just like anything else, you have to be careful how it's used, right? I wouldn't want to take a class on, explosive detonations. I mean, it might be fun, but I'm a fat lawyer. What the hell am I going to do with explosive detonation knowledge? How's that going to play into my self-defense or my home defense? It might be fun and interesting, but maybe that's one of those that doesn't go into my Tupperware container, is kind of my point. Because that can kind of make it look, like you're a wannabe Rambo. I don't want to look like a wannabe Rambo. I don't want to be a wannabe Rambo.
So I do know a trainer here in our state that had a class that the title of that class was the Gentleman Killer.
Yeah, bad idea.
And I go, why in the world would I put that on my training resume?
It's as bad as having the Punisher skull on your grips of your 1911. What are you doing? I mean, you're just asking for problems, right? You don't do that sort of thing. As I've mentioned to you before, 20 years ago, the conversation was the dum-dum bullet, the cop killer bullet, which we would just call jacketed hollow points.
Right.
And anybody that tries to bring up that argument better be prepared, because if the attorney knows the stuff and has an expert witness, you're going to rip that prosecutor's head off.
Sure.
It's just completely nonsense. It's the only kind of round you should be carrying. And so knowledge of the training that we're talking about and being able to present that to the jury in a way that makes you look very diligent and very responsible and willing to spend your own time and your own money, that's everything.
And I really think if your training and your actions look like a good, sane, sober, moral, prudent person, you're not going to have that challenge. And I will say the one thing on Armed Attorneys videos, and again, I appreciate those guys, right? But this is what we do, is we bat ideas around on the inner tubes,
That's how you
right?
learn.
I think the one thing that I was kind of like, well, I'm not so sure about that, is they said, well, okay, this guy, the prosecutor was really interested in his training record and all these things and entered it, and it was being held against him. Well, and then she looked over at him and was like, well, I mean, that guy did carry 4 guns. And
which is an issue. I had one client that was arrested with 4 guns one time, and I'm like, how am I going to handle this?
And he had, really kind of edgy posts on social media and those things. Well, those are the things that then get your training record to be something that the prosecutor's sniffing around about and wondering, why in the world are you doing these things? Because you don't look like a good, sane, sober, moral, prudent person.
The other thing that, and I apologize, I don't recall her name, but the female attorney in the Armed Attorneys duo, she raised the point, and she said, if you get that much training, it's going to make it harder for you to say that I was in fear for my life. How could you be in fear of anything? You've got all this training, and you've done all these tasks, and you've passed all these tests, and you're so competent, you're so good. How could you ever be afraid for your life? Which there's a couple of angles there. The first thing is maybe using the word fear, which we all do.
Yep.
We all say, well, I was in fear for my life. Fear does have connotations with it, right? If I watch the movie Halloween and a head falls towards the camera and I jerk and I pull away, fear is not necessarily showing cogent thought and appropriate reactions. Fear is something that can sometimes be irrational, right? So you have to be very careful with that. If you see that starting to sneak around the corner, you got to slamp it down really fast. So that's the one issue about the whole fear for your life thing that I think a lot of people tend to forget about. So,
I agree. Well, but fear in its kind of legal definition also means genuinely perceived risk.
Correct. Apprehension.
Yeah, and I apprehended that I really was at risk of my life. So just because, for instance, let's just say the example they had was a prior service Marine.
Right.
And of course, every Marine or rifleman and those things. First of all, just because you're in the Marine Corps doesn't mean you're a snake eater, okay? There's plenty of people.
About 4 jarheads getting ready to charge your house right now, so be wary.
Hey, listen, as bona fides here, my grandpa fought under Chesty Puller. My pop was 3rd Recon Battalion in Vietnam. Like, literally, I got Marines in my family blood. Yeah, amen, right? We keep the Marines around because you really can't bring Dobermans on the ships for security, so we bring those Marines around.
Exactly.
I love you guys, please. Only 3 crayons a day, too much lead otherwise. But not every Marine is a snake eater, but also, okay, so let's just say you really are really good and you don't experience the irrational or the subjective idea of incoherent thought and flinch. Well, that doesn't mean that you didn't actually apprehend that there was a real risk and act on that risk.
And the world's most highly skilled, highly trained virologist, a doctor in a lab with quadruple security levels with the intake air, et cetera, et cetera. Is he afraid of viruses? Probably better be. Right. He knows the risk that they pose, so he is very educated and smart about the safeguards that he uses to prevent that virus, right? I appreciate violent crime. I'm apprehensive about the risk of violent crime. I train to lower the risk to myself and my family and my loved ones of being a victim of violent crime. It doesn't mean I'm immune to it or that I shouldn't be worried about it because I know more about it than the average Joe. It means perhaps I'm even more worried about it.
Right.
So,
and I also think that the idea that says, okay, wait a minute, if we're in criminal court, we have a prosecutor that says what we did was wrong. We did the wrong thing.
You wouldn't be there otherwise.
And so is so convinced that what I did was wrong that they think they've got a very high chance.
Or, let's be very honest.
Or they feel politically they have
Or it's politically motivated, yeah. And unfortunately, that's part of the conversation these days.
Hi, Mr. Rittenhouse. We're talking about your case.
Yep. Or Zimmerman.
Yeah, George Zimmerman. Okay, so if you watch those two cases, if you actually go watch the trials, those prosecutors should be tried for misconduct.
Yep.
But the point being, like, if instead what I've done is I have set myself up as a good, sane, sober, moral, prudent person, only did what I must do in the moment. I didn't use lethal force cavalierly or on the sketchy edge cases where people always ask me about, John, can I shoot someone?
That's a horrible question.
Yeah, and I always say, don't ask can I, ask must I.
Or not even, I always say, rather than say can I, because it's not a hunting license or a permit that you're getting, right? I always say, instead of asking me, this guy did this and this, can I shoot him? How about if you ask yourself, this guy did this and this, I've thought of this, this, and this to avoid having to shoot him. Can you think of anything else I haven't thought of to avoid having to shoot him?
Oh, I love that approach.
That's the way I look at it. It's like, look, your goal is not to have permission to shoot someone. Your goal is to figure out every way possible to avoid having to shoot someone.
And listen, I think that having my training is not in a box; it's on a folder, and I've got tons of completion certificates. And you guys know, I like going to gun school, right? You see it on the channel all the time. I ain't hiding from a prosecutor what my training calendar looks like. And on the other hand, so I think you can go one of two ways. Their advice at the end was be very gray man and very quiet.
Great advice.
Which is fine advice. Yeah. Or I think the alternative is be unimpeachable. Be so good at what you do. If God forbid I'm ever in a gunfight and a prosecutor says we're going to nail this guy, now hopefully I made good decisions, right? But if it was a politically motivated thing or whatever, then I could say, well, I mean, by all means, send some interns to watch 6,000 hours of me on video. And
don't forget, those two things are not mutually exclusive. You can be gray man and still be unimpeachable.
That's true.
Right? I mean, you don't walk around with your kill 'em all and let God sort 'em out t-shirt. Don't walk around advertising the fact that you're armed or that you're ready for a battle, because that encourages that, right?
Yeah.
That's idiot. That's non-gray man. But you can be a gray man and still be somebody that shouldn't be tangled with, right?
Yeah.
And so you can make unimpeachable decisions and perform unimpeachably, but still have a low profile that wasn't asking for it or broadcasting. I think that's the best combo right there.
So to circle this all back, Federal Rules of Evidence 404 says bad prior acts. Now, when we open the doors in a self-defense case, though, now our background can indeed come into play.
And again, I would argue that those aren't bad prior acts.
Right.
Being trained
those are
is
good
not
acts.
a bad prior act. That's a good thing, right? And again, in most I always hesitate to say ever, never, but in most self-defense cases, I'm going to be the one that introduces that evidence.
Right.
I'm not going to be worried that the prosecutor is going to bring it out.
My client has invested their own time, their own money,
thousands of dollars, hundreds of hours.
I would say especially in legal use of force classes, in classes that have, trauma medical, in classes that use less lethal tools. Here's all the things. They did everything they could to avoid using their firearm. But in this case, they had to.
That's right.
And because they had to, then that was the only right answer. Yeah. And I think that ends up being a net positive, unless you're the dude with the Punisher skull shirt, carrying 4 guns, talking about kill 'em all and let God sort 'em out on the social medias.
And frankly, every time I've met one of those guys, and I'll bet you're the same way, you don't want to be around them. They're scary dudes. They're off-putting. They don't get it. They're making it bad for the rest of us. They're false advertising. They're terrible. So don't be that guy.
Now, at the very end, I would say, do you have a right to carry 4 guns? Unless you're living in New Mexico. New Mexico CCW says 1 gun. A few CCWs say 1 guns. But in most places here in Arizona, you carry. I don't care. You can be, Boondock Saints and open that sucker up, and you got, New York reloads as far as the eye can see. I don't care. Knock yourself out. But recognize that's gonna
Equitas veritas.
Yeah, that's gonna get to the jury though. They're gonna see that goofy stuff.
Yeah, I mean it's extremely rare. I don't think I ever carry a backup gun unless I'm on duty with the Rangers. And there's a lot. Yeah, I'm not saying it's a bad idea. I just don't know that I've.
I have a video on the channel about why private citizens don't need to carry backup guns.
Yeah, I tend to agree with that. But that said, like you said, you have a right to. But at some point, a third, a fourth. Oh, and you've got the 22 Magnum in your
Ninja
sock?
Stars. course.
Yeah, exactly. I mean, calm down. It just looks silly. Yeah. So
A lightsaber, anyhow, that's Rules 404, guys, and how your training calendar can be used in a helpful way. Tim, really appreciate the
always, buddy. Thanks.